Good evening, ladies and gentlemen. May I warmly welcome you to the webinar organized by the Overseas Committee of the Bar Association of Sri Lanka on current challenges to aviation and legal problems faced by the international civil aviation. So before we start, let me very humbly invite our president, Mr. Kaushal Navaratna, to address the gathering very briefly.
Yeah, thank you, Janaka. Good evening, ladies and gentlemen. First of all, let me express my sincere gratitude on behalf of the Management Committee, Executive Committee of the Bar Association for all the resource persons, Dr. Abiratna, Dr. Hettiarachchi, and Madam Wickramasinghe for taking your time off from your busy schedules and to impart our knowledge and to share your knowledge with the members and the rest of the participants on this the specific the field of law. And as far as the Bar Association is concerned, we have set up certain subcommittees, especially one of the most important subcommittees of the Bar Association in its operation is the Overseas Relations Committee headed by Dr. Gunawansa and ably supported by Janaka and a few other senior members of the legal profession who have taken very progressive steps to educate the membership as well as all the stakeholders, and this is one of such programs. So therefore, your knowledge and your experience in the field of aviation, I'm quite confident will be an immense the support for the practitioners as well as the participants to have their knowledge brushed up and to make use of the knowledge what they acquire. They will apply the process of this program for their the practice or the respective profession. So whilst thanking Janaka and Dr. Gunawansa and the rest of the members of the Overseas Relations Committee, and once again I extend my gratitude to Dr. Abiratna, Dr. Hettiarachchi, and Madam Wickramasinghe for coming on board with the Bar Association of Sri Lanka and sharing your knowledge with the rest of the members. Thank you, and I'm really looking forward for a fruitful discussion through this webinar today. Thank you, Janaka. I think you're muted.
Sorry about that. Thank you, sir, for those kind words, and we really appreciate your ready support whenever we ask for your assistance in organizing these events. So without much ado, let me very briefly introduce our stellar panel tonight. If I may actually go into their proper profiles and CVs, we won't be able to have time to discuss the subject matter. So let me do the justice of keeping it very brief, but at least give a round of introduction as to who they are. So we have as our first speaker, Dr. Ruwanathissa Abiratna, a proud product of Sri Lanka. He worked in the field of aviation law and management for 30 years. He also worked as a senior legal officer at the International Civil Aviation Organization until he retired in 2013. So that was 23 years of service there. As senior legal officer, he headed the Treaty Office of the International Civil Aviation Organization, which is also called ICAO, and advised states on their registration and depository obligations with regard to the international treaties and their adherence thereto. Prior to his position at ICAO, Dr. Abiratna worked for 20 years in the Air Transport Bureau of ICAO, where he rose to the ranks of acting director, being responsible for safety, security, environmental protection, and economic issues of the organization. So you can see, gentlemen, he's head to toe an expert in the civil aviation area. So before joining ICAO, he was for 8 years at Sri Lanka, serving at Sri Lanka Air Lanka at that point of time as the chief coordinator and head of international relations and insurance. Dr. Abiratna holds a degree of doctorate of civil laws from the McGill University, the degree of Doctor of Philosophy, PhD from the University of Colombo, a degree of Masters of Law from the Monash University, Victoria, Australia, and a degree of bachelor's from the University of Colombo. Dr. Abeyratne has authored 24 books and more than 400 papers in academic and professional journals on this very same area, sphere. His professional reputation rests largely on the works of aerospace law and economics. Dr. Abeyratne's current academic research is focused on air transport economics and aviation and climate change. He holds an impressive record of teaching and at graduate level for 22 years in the field of international law and relations and public policy. He's a fellow of both Royal Aeronautical Society and Chartered Institute of Logistics and Transport, and a member of the International Trade Law and Space Law Committee of the International Law Association. Dr. Abeyratne is also a member of the editorial boards of several international law journals. It's more than a pleasure to have you here tonight, sir, as a guest speaker. Then, of course, we have Dr. Lasantha Hettiarachchi, who is well known to us as a civil practitioner. He holds a doctorate. He's a doctor of civil law in air and space law from the same university, McGill University, Montreal, Canada. It is called Institute of Air and Space Law, to be very specific. He holds a Master's of Law, an LLM in Air and Space Law, which he had obtained in 1992 from McGill University again, Canada. He's also a practicing lawyer in his illustrious practice as a civil practitioner, over 33 years of experience in civil litigation. He handles an array of original and appellate court work, ranging from commercial arbitration, transactional advisory, services in corporate and commercial law. Areas of practice include aviation, telecommunication, finance, banking, security, and corporate and project financing, corporate restructuring, mergers and acquisition, foreign investment, infrastructure development, and many other areas of law. He is serving as an independent director of Alliance Finance PLC, as a member of the Related Party Transaction Committee, and he's a legal consultant to various other national and private sector bodies. Dr. Hettiarachchi also has contributed into the legal literature of civil aviation on various journals, and then there are a number of articles that have been published on the same discipline. I don't want to go through all that. There's a long list. I welcome you once again, Dr. Hettiarachchi. It's a pleasure to have you on board. So last but not the least, we have our very own able moderator tonight, Madam Anusha Wickramasinghe. Ms. Anusha Wickramasinghe is currently serving as a lecturer at a number of public and private universities and institutions in Sri Lanka, especially on the civil aviation area. She lectures on aviation law, space law, laws on international business structures, and public international law. This is at undergraduate and postgraduate level. It is also mention worthy that Mrs. Anusha Wickramasinghe is a graduate of Open University of Sri Lanka and holds a LLM from the Institute of Air and Space Law from the McGill University. She is currently reading for her PhD in at the International Institute of Air and Space from the Leiden University, Netherlands. She has published several journals, articles on various issues pertaining to air law. So with that brief introduction, let me now hand over the proceedings to Anusha to commence today's interesting discussion on civil aviation. Before we move on to that, I have few housekeeping messages. If you have any questions, you may post them at the Q&A session, which will take place towards the end of these presentations and the panel discussions. However, if you wish to, you can even use the chat box and write down your questions so that we can take them up at the Q&A session. With that, let me now invite Anusha Wickramasinghe to commence the proceedings. Over to you, Anusha.
Thank you very much, Mr. Basuria, for your kind introduction. Hello and welcome from me again, actually, to this webinar. Today's webinar is on current challenges to aviation and legal problems on international civil aviation. And again, actually, my name is Anusha Vikramasinghe, and I'll be moderating this webinar. We are into an industry. The air transport industry has long been considered as one of the most dynamic and actually, ever evolving industry, from actually commercial airlines to private jets, cargo carriers to aerospace manufacturing. We always strive for the best. I use the word we because we all belong into that sector one way or the other. Right. So again, actually, before I start, thank you very much, all our audience participants, for taking interest in this webinar, in this session. Maybe something new for some of y'all at least. Right. And thank you again for taking time in Saturday afternoon, Saturday evening for some, and of course, for our experts also, thank you very much. Dr. Abiratna, it's morning for you on a Saturday for taking time off to share your expertise with us. And of course, let me introduce the structure of the webinar. As Mr. Basuria actually mentioned, we have two highly distinguished speakers. First, we'll listen to the presentations of our speakers. Then we'll have a panel discussion, which will be followed by a Q&A session. So as actually Mr. Basuria said, during the Q&A session, we encourage you to speak and ask your questions after raising your hand. Or if you prefer, you can write the question and send it on the chat function as well. In each case, please identify yourself and affiliation and to which speaker you are actually putting the question to. Please note that this session or this webinar is being recorded. And please keep your microphones and cameras turned off during the session to secure a good connection. And please turn them on when you have to ask your questions. And after asking the question, again, please switch off your mic and, of course, the camera. And, of course, with that, I take the privilege of introducing our first guest speaker, Dr. Ruantisa Abiratna. Again, actually, Mr. Basuria gave a very lengthy, introduction. And let me actually repeat it. Dr. Abiratna has actually a lot of experience in both the academia, in practice, and of course, in terms of aviation law and management for years. And of course, as Mr. Basuria said again, he had authored 24 books so far. And I'm sure, sir, you have written more than 450 articles, papers by now. So I bet a researcher who's trying to write a paper on any aspect, aviation security, air navigation, space law, aerodromes, anything, right? You can't write a paper without referring to Dr. Ruantisa Abiratna. With that, we welcome Dr. Tissa Abiratna for the first session. He'll be speaking on international civil aviation law, global trends, and current legal problems. Please welcome Dr. Ruantisa Abiratna. Over to you, sir.
Thank you, Anusha. Thanks very much. I think I should begin by marking my appreciation to the Overseas Relations Committee of the Bar Association of Sri Lanka for inviting me to this discussion. I'm also very grateful to Mr. Balasuria and also Anusha for the very kind words that you mentioned. It is a pleasure for me to be here. Particularly, the subject is very interesting. Just to say a few preliminary words on aviation before I get to my presentation, I would like to go back to what Charles Dickens said in his Tale of Two Cities. We are in the best of times and in the worst of times. Why are we in the best of times in aviation? Because just this morning, I was watching BBC Business News, and they introduced a CEO of a firm called Jet Zero, which is developing blended wing aircraft as against fixed wing aircraft now. And these blended wing aircraft, which will be coming into operation in 2027, would mark a 50% decrease or improvement on lift, weight, and drag of the aircraft, which will give 50% efficiency in terms of fuel consumption. That's a huge advantage. And as we go on this discussion, we will see what things like artificial intelligence contributes to aviation. Why are we in the worst of times? The worst of times is because of COVID, of course, and we have just got out of it. Our figures, our statistics are good, as we will see in a few moments. But at the same time, from a COVID crisis, we have got on to what is called a supply chain crisis, where there's a huge dearth of parts, a huge dearth of human resources, and the airline industry is also having a dearth of pilots. For example, in the United States, 12,500 pilots are needed, and only 6,000 pilots are produced every year. Now, that having been said, just a few words on why is aviation facing all these challenges? Purely because of the nature and the law and regulation of aviation itself. Aviation is completely different from other modes of transport for a couple of factors. First is, you can take a train from parts in Europe, countries in Europe, one over the other without permission of the recipient state. You can take a ship anywhere without negotiating and formal approval and agreement from the recipient state. But you can't do that in aviation. Why? Because there is a provision in an international treaty, the Chicago Convention of 1944, which in Article 6 says no scheduled international air service may be operated into a country without that country's specific agreement and approval. Now, that requires quite a bit of negotiations and permission and protectionism and commercial interests and so on. This is quite different from, say, the ships. For instance, to be a bit pedagogical, Hugo Grotius, who was the father of international law, a Dutch jurist, in his famous book Mare Liberum, which means free seas, talked of the open seas. And here we have the exact opposite. Number two, you have to have generally substantial ownership and effective control of the airline by at least 51% of the nationals of a country. Why again? Because Article 17 of the Chicago Convention says that an aircraft bears the nationality of the state in which it is registered. This is different from flags of convenience and so on. Number three is that up in the air, 40,000 feet maybe, if something were to happen, there is the Montreal Convention, I think Lasantha might refer to it later on, which in Article 17 says that the carrier will be liable for damage caused in the case of death or injury in the aircraft if the accident which causes the death or injury occurs on board or in the process of embarkation and disembarkation. This, in essence, is the presumption of guilt and not the presumption of innocence. For instance, the Montreal Convention says that if such a thing were to happen, there is an upfront payment without questions asked of 100,000 special drawing rights. And then, of course, the carrier would have to bring in various things to say that the passenger concerned or the claimant is not entitled to more. Now, these are just a few differences that are inherent challenges by the very laws and regulations of aviation, which is completely different from other forms of air transport. Another thing before I get on to my presentation is there are two things, even if we don't remember anything about aviation, which distinguishes aviation as well. And those are two words called standardization and harmonization. Standardization, in essence, means compliance. You have to comply with the laws and regulations of the Chicago Convention and the 19 annexes, which lays down like operations of aircraft, environment, licensing, and so on. Number two is harmonization, which is global consistency. Without global consistency, which means the Annex 2, which is on the rules of the air, operate for every aircraft, every airline, every state who are members of the ICAO and contribute to the Chicago Convention. Now, those are the sort of the basic facts. And now I'll try to get on to my presentation because I'm aware of the constraints on time. and I'll be as quick as possible. Can you see this?
Yes, yes, doctor, we can.
Yes, we can.
Okay, so I'll get on with this. Now, the first things first is where we are at the moment, and we have a saying in ICAO. I'm sure this is common to most places, that without statistics, all that you have is only an opinion. So I sort of collected a few statistics to see where we are at the moment. And that's called recent developments. In 2019, now this before COVID, passengers carried were 4.3 billion, freight 58 million tons, supported jobs 65.5 million, 3.6% of the global GDP, interconnected with tourism, supporting 37 million tourism-related jobs. Now, IATA now gives industry forecast, which is actually quite bright. It said that the airline industry will strengthen in 2023. Net profits are these: 9.8 billion, 1.2% net profit margin. Positive development: China's early COVID-19 restrictions lifted, cargo revenues will remain high, and jet fuel prices moderate. Total revenues to grow by 9.7% into $803 billion US. And first time the industry revenue will surpass $800 billion since 2019. Now, having said that, there are a few things that are fairly problematic. That is that according to the recent statistics, leisure travel has increased actually over 2019 figures, but business travel has fallen. So now the trend is that although leisure travel will start increasing and keep on increasing, because of the backlash and the offshot of COVID-19, where businesses started doing things on Zoom and using electronics and information technologies, that business travel will decrease. Now, that is where the airlines sort of get their major part component of the cost recovery and profits. So that's they are to be just remembered. Another thing is the expense growth. Sorry, it's 8.1% static. So now, what are the transformative trends in aviation? Quantum computing. I'll get back to that in a moment. The growing trend of building fuel-efficient aircraft. I just mentioned the blended wing aircraft, but at the same time, there is also a huge shift towards biofuels, and even on a long-term basis, hydrogen fueled aircraft. Biofuels, of course, is closer. It's right now costing about 3 times more than traditional conventional fossil fuels. But it's growing, and research and development is there. So this is actually an exponential trend. There is, as I mentioned, biofuels and hydrogen fuels, and there are various advantages of hydrogen fuels. Zero emissions, for instance, high energy density, reduced noise pollution, fuel versatility, reduced dependency on fossil fuels, potential for regional connectivity. So now, when you are talking about regional connectivity and all that, I must mention that very quickly, the Chicago Convention, with its 98 provisions, has a comprehensive array of laws. Actually, it's an international treaty. There are 193 states right now who have ratified the Chicago Convention. And the Chicago Convention's preamble is the main theme for this connectivity. And the connectivity part of it is the main, actually, challenge, as well as the asset of aviation. If I may just recall, the Chicago Convention, in its preamble, which sets the theme for the convention, says, whereas the future development of international civil aviation helps preserve friendship and understanding. Now, that's connectivity. friendship and understanding between nations, yet its abuse could be a threat to general security. Therefore, there has to be cooperation and avoidance of friction. And the Chicago Convention's preamble in its last paragraph gives the 3 elements that aviation has to go through and be practiced. And that is that it has to be developed in a safe and orderly manner, which means safety and orderliness. And then it has to have equality of opportunity, not fair and equal opportunity. It's different. It's equality of opportunity. And the equality of opportunity is not to operate air services, but to have the opportunity, equality of opportunity to compete. That means that there are certain principles that have to be followed, and these have been developed over the years through mainly ICAO and all that. And also the third limb is that it has to be developed. Air transport has to be developed soundly and economically. So you have the economics part of it, the technological part of it, and also the equity part of it woven in. So anything that we do, whether it's quantum computing or hydrogen biofuels or technology, these elements are what govern the basic air transport principles. And we have to remember that whatever we talk about, like security or safety or manufacturing of aircraft or anything, there is only one product, and that is the air transport product. Without the air transport product, all these things about safety, security, and environment and so on will not be a consideration. So we have to concentrate on what the air transport product is and what the challenges are and the legalities of this particular product. So regulators are imposing tighter restrictions, of course, on emissions and noise, and we'll get to CORSIA in a minute. Manufacturers are compelled to develop more efficient aircraft models, and I just mentioned very briefly an example of what is going on. But there are lots of things happening, and what they say is that if we go on the way we do in terms of maybe aircraft engine emissions and all that, without taking measures, by 2050, the current contribution of 2% of carbon dioxide emissions to the global atmosphere by 2050 will be 22%. So we have to keep in mind the Paris Agreement of 2015, which brought emissions level down to 1.5% on our pre-industrial levels. To maintain that, what we are going to do, and that's a huge challenge. I would say that the most compelling challenge to aviation is the climate change challenge. So the impact is very severe on aviation sustainability. So now electric propulsion and hybrid technology is something that we're talking about in terms of, I saw American Airlines or Delta, one of the airlines, in a 777 aircraft, the right engine is purely run on biofuels. So, and hybrid technology. So they are right now developing these technologies, and also they are thinking of introducing a long-range flight in the next couple of years purely on biofuels and the other technology that is available. So this has potential for long-haul flights, yes, and the end thing is long-haul flights, because long-haul flights are the more difficult ones. These are the ones which are over 3,000 kilometers away, flights which cover 3,000 kilometers and over. Then you have the drones application in terms of propulsion and modern technology, and small planes. In the medium term, these are very possible. And then you have the autonomous flight and artificial intelligence integration. Now here, I must mention, and maybe later on mention will be made as well, on the repercussions, implications, and consequences of autonomous flight on the current treaties and international law which governs aviation. I'll perhaps explain that when you come to the point. Increasing interest in autonomous flight, but it is a bit distant right now. But at the same time, aviation is a thing that we look at long term more than even the short term. And also, it's one of those things that are very cyclical in terms of economic interest. It goes up and down. For instance, before COVID, or rather 2020, for 10 years, global airlines on an average made net profit. Now they are trying to slowly climb with the supply chain problems and the resource problems and other problems that are affecting the profitability, such as the business travel and so on. Now, the necessity for regulatory adaptation to non-human driven systems is very, very real, particularly because one has to remember that this is not a self-driving truck. This is a steel tube full of 200, 300, 400 people. And the human element is much stronger than the technical element when you go to look at it on a nuts and bolts basis. So manufacturing innovation is continued emphasis on lightweight, durable materials to release or reduce the lift weight and drag, fuel efficiency, environmentally friendly aircraft. I referred to it rather briefly in terms of the fuel, engine emissions, and so on. And much has been done actually on the international level. For instance, ICAO has done a lot of work on the thing called CORSIA, which is the carbon offsetting and reduction scheme for aviation. It has its drawbacks, and I might refer to it a bit later, maybe even in the conversation part of it. Supersonic aircraft. Right now, supersonic aircraft are being looked at, perhaps even built with NASA, the National Aeronautics and Space Administration collaboration. Air mobility and urban air mobility is another thing, which will again bring in lots of possibilities, but at the same time challenges when you're talking about liability and linking urban liability transport to international transport. And the significance would be for us lawyers to start from at this point in time. There is no point in waiting for these to come into fruition and then start thinking about it. Therefore, these are possibilities that have to be turned into possible treaties, legislation, regulations, and so on. Vertical takeoff and landing, that's another thing which is happening right now actually in urban settings. And these would have repercussions. And I must mention something that when you're talking about drones, you might ask, drones are essentially local. Drones are essentially domestic. Why would ICAO be involved? And this question has been asked and answered. I don't know whether this is the correct answer, but the answer has been, well, we are not concerned with domestic drones because we are the International Civil Aviation Organization and the Convention on International Civil Aviation. So everything has to be international. But then 9/11 happened, and that happened domestically, and ICAO had to get into the picture. Why? On what basis? International travel will end up in a domestic arena where international travel will turn into domestic. And I remember in the council, it was decided that we no longer are purely international. Because, for instance, even environmentally, engine emissions and all that, you cannot demarcate emissions purely on the basis of geographic allocation and so on. So that is one thing that has to be addressed, maybe considered in terms of the urban air transport as well, in terms of a possible link for seamless regulation. intracity flights, which obviously are connected in one way or another to international. Then we have data analytics and quantum computing. So these are very relevant things for not only the passenger experience, but introduction to quantum computing as a transformative technology. Let me explain. Now, in terms of computing, or rather the development of technology, we have three phases. The first phase was the analogs. And now we are in the digital stage, and we are just getting into the quantum computing. So what's the difference between digital and quantum? Digital is from top to bottom. So if you say take an example of a maze where you put a rat in a maze and ask the rat to go to the end where there is some food, the digital part of it would go from top to bottom. But the quantum part of it will go through the entire maze at the same time and then come to the conclusion, meaning that it will be so much quicker, so much. One expert had put that to 200 million times quicker than the normal digital. So what does it mean for aviation? Look at meteorology. Meteorology, weather forecasting, performance in the aircraft, of the aircraft. If you use quantum computing, the result will be much quicker. I just take an example. In December 2014, an AirAsia aircraft was taking off from Surabaya in Indonesia to Singapore. And over the Java Sea, it crashed. Now, the thing is that the weather was pretty terrible, but the problem was that the aircraft generated so many stall warnings that the pilots did not know how to attend to that or respond to that, and they were not trained, in other words, and the aircraft crashed. That's what the report said anyway. Now, there is absolutely no fault in the airline itself, except that thing like quantum computing would be much quicker and much more efficient in terms of attending to such a problem, maybe even taking over and rectifying the situation. So it is certainly a transformative technology. And also it extends to cabin designs, entertainment systems, connectivity, and so on. There is another aspect to this. Now, for instance, say an airline has 25 aircraft all over the world. Now, quantum computing will establish a system as against digital computing where the performance of all those aircraft at any given time would be known by people who use quantum computing. Now, that's a huge plus, a huge advantage in terms of efficiency, safety, even security, for example. So they can optimize flight paths, routes through complex calculations quickly, reduce fuel consumption and environmental impact, enhance air traffic management systems for safety and efficiency, improve weather forecasting accuracy and turbulence prediction, and enhance global navigation systems, GPS precision. So in every possible aspect, quantum computing would be an immense boom to aviation, and it's coming. Now, the thing is, when it comes, what do we do? What are the laws and regulations which would have to be looked at? So those are some of the things that people at the helm of aviation in any of the 193 states would be focused on in the coming years. Securing aviation data through quantum computing would be another. So the data aspect of it would be 100 to 200 million times more efficient, quicker than the digital setup. In terms of manufacturing and maintenance, optimizing aircraft aerodynamics. Just an example. This might come up in later discussion, but what what really happened in terms of the Boeing 737 MAX 2 crashes, Lion Air and Ethiopian Airlines. There was this system which was highly sophisticated, which was introduced, called the MCAS, the maneuvering system. I forget now what it's called. And that was something that would calculate the lift of the aircraft and the takeoff and subsequent travel. And there was a thing called the line of attack just opposite the aircraft, opposite the cockpit, to manipulate the stall effects of the aircraft, the threats, and that went awry. Now, that kind of thing, it can't be blamed on anyone. It was according to the technology available and all that, but quantum computing would, because it's systemic, it would be much quicker, much more efficient in identifying something like that, even at the manufacturing stage. Eco-friendly aircraft systems, that is a given, purely again in terms of reducing the lift, weight, and drag, and also the fuel efficiency of aircraft, because we are aiming at net zero emissions by 2050. Now, to attain that, we need all these kind of things in terms of modern technology. Predictive maintenance through large data set analysis. Again, because it's systemic, it will be more predictive and more anticipatory than the current digital system. So it is a very pivotal role that quantum computing will play in terms of speed, efficiency, and impact on various fields. There is also this thing called quantum parallelism, which is, I refer to it in sort of layman's terms, and that is the ability of a quantum computer to perform certain types of calculations exponentially, which is gradually increasing faster than classical computers by processing multiple possibilities simultaneously. This is crucial to aviation, because in aviation, the flight per se is heavily automated and heavily dependent on modern technology. So quantum mechanics is based on particles like electrons and photons, which exist in multiple states simultaneously rather than one by one in the single state, which is ordinary normal physics. This property allows quantum computers to explore many different computational paths at once. So now we get on to the challenges. Environmental regulations. Aviation's impact on the environment has led to discussions on potential legal development. So this is an area where ICAO has, International Civil Aviation Organization, has been working for the maybe past 15, I don't know, even 20 years, very robustly and with dedication, and also with conscious awareness that this has to be addressed. And the final product is called CORSIA. I mentioned that, CORSIA, that is the carbon offsetting and reduction scheme for international aviation. Now, that is based on offsetting and reduction, which means the purchase of carbon credits allocated to certain airlines on a formula, and they can't go beyond that, but they can buy carbon credits from airlines which maybe do not generate that much carbon in there. So it's a sort of a barter system. And the problem is that it has been rather sort of criticized for various reasons. And also there have been proponents who say, well, instead of a offsetting scheme, we have to have a carbon tax, and that carbon tax should be more efficient, because the emissions of carbon dioxide can be calculated on any flight on any type of aircraft. So that is an ongoing thing, but of course it's hugely popular, and also I must say that majority of the states accept that as a viable solution. the aviation industry's carbon emissions have gone through a lot of evolutions and iterations, and CORSIA has been the one that sort of came out as the most feasible. One of the arguments for CORSIA is that, if you just put a tax on carbon, say, that is easily computed, and it has the International Monetary Fund and also one of the economists, Thomas Piketty, who wrote a book on capital, he also advocated this, because on the face of it, there's nothing wrong with it. But the argument is that aviation is based on any levy made on aviation to be cost related and to be put back into aviation. So the basic policy is that if you have a passenger charge, if you have an airport charge, certainly you can have it, base it on the cost of providing that service, and then what you collect should go back into aviation. Now, in a tax, it's not the case. You can tax, have a school tax or a property tax, and then take that tax and put it into education or health or whatever it is. So those are the things that are right now being discussed. Passenger rights to be also a focus. It will be a focus purely on the basis of the loss of privacy and so on. Lasantha might elaborate on it because he has practical experience on this. Regulations related to flight cancellations, delays, and so on. Denied boarding, compensation for passengers, that's happening all the time. Even in developed parts like where I am, delays are fairly common. I wouldn't say they are frequent or the rule of the day, but still it happens. So data privacy and cybersecurity have become very, very important, and that is still sort of up in the air, kind of. And I thought I'll say a few words on cybersecurity. The main threats are state-sponsored attacks, cybercrime, of course, it's an industry now, hacktivism, aviation's vulnerability being a patchwork of systems, dependence on timeliness of services, and no federated, trusted cyber resilience network. So there is a compelling need actually to address this in terms of cybersecurity as it affects aviation. Now, having said that, even treaties, like for instance, liability in terms of crimes committed against aircraft, onboard aircraft, and so on, there is only one convention right now, international treaty, which addresses cybersecurity in an indirect sort of way, but it certainly does against the safety of civil aviation, and that's the Beijing Convention of 2010. This is a very important convention and a treaty. And maybe we'll, again, in the conversation, we will discuss that particularly. I think.
I'm sorry to interrupt, sir. You have 5 more minutes.
Oh my goodness. Okay. So I'll go through this very quickly, and then we can start chatting. So regulations are being developed to protect passenger data, airspace management, and unmanned traffic management. As drone use becomes more widespread, there is a need for effective airspace management. And here I refer to the economic aspects of it, bilateral, multilateral agreements, permission to be granted and all that. The impact of COVID, that was, of course, very palpable. Space tourism, where you have to distinguish whether a spacecraft takes off as an aircraft and then becomes a spacecraft and so on, and also emerging technologies. So drone regulations are very heavy, and of course there has to be a link between the international and national aspects of it, environment and so on. Passenger rights, we were talking about cancellations, delays and all that, data privacy and security, protecting passenger data, and UTM, unmanned traffic management, and managing traditional aircraft and drone safety. And of course, international arrangements in terms of addressing air traffic rights and safety. ICAO, finally, last session of the Assembly in 2022 adopted resolutions on various aspects, but very particularly on the law. Infraction of the convention by Belarus. We can discuss that if needed in terms of the discussions that we followed. Then again against Russia for closing its airspace. That's another huge area which has been put into treaty, but of course not always followed. Then the Democratic People's Republic of Korea and the missiles that they launch over countries. So the legal advisor, again, there was discussions in the Assembly on what the legal advisor should be, must not only know the law and treaties, but be able to acquire knowledge, related experience, be a qualified lawyer holding a law degree, need not necessarily be an aviation law degree or equivalent professional. These are the requirements that were recognized, relevant sufficient knowledge and competencies and so on. So now, finally, what should be done? There are lots that can be done within the existing legal framework, and you can sort of pick one by one and then see what is prescribed. And there are lots of things prescribed. So crisis management capacity is one. ICAO collaborating with the World Health Organization in terms of the crisis, health crisis. And also regional officers should keep ICAO very closely advised. And finally, I bring this up. Question, how does a wholly automated aircraft decide where to carry out a forced landing if the choice is between a school playing field and the gardens of a retirement home? This is a conundrum that I think should be discussed if automated aircraft ever come into being. And my question always has been, when US Airways the aircraft was, both engines were hit by bird strikes. Captain Sully, who was the pilot, had to land the aircraft on the Hudson. This was a domestic flight on the Hudson River. And passengers all were rescued. But the captain walked up and down, assuring trying to assure himself of the safety of the passengers. Now think of IBM's Watson or something like that, doing that if there is a crisis. And then you come to the Tokyo Convention, the in-flight security officers and all huge discussions. And the ultimate thing is that artificial intelligence should be a supplement and not the whole solution. And also, existing treaties have to be relooked at on that basis. So these are some of the sources that I use. And finally, to grasp the world of today, we are using a language made for the world of yesterday. So that seems to be the problem. Aviation in the world of technology, digital technology, transcending the earlier world of information and ICT. This is another statement. There are three factors that will dominate our world: increasingly capable systems. I follow Thomas Friedman, a very well-known journalist, who said there are three M's operating now: the market, Mother Nature, and Moore's Law. Market is not the ship that took cargo from one place to the other, but our whole market. We are all players in the market. We can get into our computers and do that. That's a modern current thing. The other thing is, of course, Mother Nature, climate change, floods, all kinds of things. And Moore's Law. Moore's Law is that in an integrated circuit, the chips are doubling every 2 years. So how do we cope with that? Integrated technology and quantified society. So there is no room for doubt that aviation is in the throes of these factors. And finally, I must beg your pardon. I just put 4 of my books which were published last 4 years, one each year. And these books, I'm not trying to tout them or advertise them, but my arguments were premised today on what I wrote in these 4 books. Thank you so much.
Thank you so much, Dr. Vanti Saberatne, for your inspiring and it was very inspiring lecture, and it's very wonderful and thought-provoking as well. I'm sorry to have disturbed you, sir, but we can listen to you on and again, but we have time constraints. Right. Without transition, now I take the privilege of introducing our next guest speaker, Dr. Lasantha Hettiarachchi. He is the head of chambers and president partner of law chambers of Lasantha Hettiarachchi. And as Mr. Janaka said, Dr. Hettiarachchi too has more than 30 years of experience in legal practice, and he has actually represented a lot of airlines, passengers, pilots associations, manufacturers, leasing companies, etc., related to aviation-related matters. Dr. Hettiarachchi's expertise is not limited to civil aviation alone. He is also a very experienced lawyer in company law, mergers, acquisitions, banking law, and law of property likewise. So today, Dr. Hettiarachchi will speak about the importance of the role of legal advisors in civil aviation and air law practitioners, passengers' rights, compensation for passengers, and bilateral and international regulation of air transport. Welcome. Please welcome Dr. Lasantha Hettiarachchi. Over to you, sir.
Thank you, Anusha, for the kind words of introduction. And I must say, after that very insightful, thought-provoking, and interesting presentation by Tissa, Dr. Ruanti Saberatne, which covered a wide and multifarious range of issues relevant to today's aviation industry, I will now attempt to give a local flavor to these issues, particularly from the perspectives of a practicing lawyer in Sri Lanka. As we are all aware, air transport is a main mode of international transportation for passengers who come into and go out of Sri Lanka. It is also used extensively for transporting cargo and mail to and from Sri Lanka. It's an island. We have to rely on air transport. Therefore, air transport is indispensable and an essential facility for global connectivity and international commerce of Sri Lanka. Unlike any other mode of transport or terrestrial transportation, air transportation is not limited to national or geographic boundaries. It can go from one territorial jurisdiction to another within a very short time, and in one journey would cross several territorial jurisdictions which are subject to different sets of laws and regulations. So therefore, regulating international air transport has to be done at a global level to ensure uniformity of laws and regulations, and must be complemented by sound application of those laws and rules, both internationally as well as domestically. Now, if you look at a vehicle that is driven in the United States, people might drive on the left side of the road. And you go to England, a person might, in the US and the continent of North America, people drive on the right side of the road, whilst in England, Australia, and in Sri Lanka, we usually drive on the left side of the road. In aviation, you can't have people driving on different sides of the sky. You have to have a uniform set of regulations that governs international aviation so that they all adhere to an accepted set of standards and practices which are applied all across the globe. Now, this is the role of the regulator. The Chicago Convention, which Dr. Aberatne referred to many times over, was the cornerstone of international multilateral consensus, where all the states have agreed to a certain set of principles which have to be applied uniformly across all the countries, and the countries that have signed, ratified, and given effect to that convention, including Sri Lanka, have agreed to abide by those uniform rules for aviation, not only in respect of its own airlines and aircraft, but also when other aircrafts operate into and out of Sri Lanka. Now, as I mentioned, I would like to give this discussion a local flavor, primarily because my main objective here is to evoke a lot of interest in this field, particularly for a crop of young lawyers, to seize the opportunities, seize and explore the numerous opportunities that are available in this area. Now, as Dr. Abhiratna mentioned, there is a shortage of 6,000 pilots in the US. And with the growth of aviation, many more pilots are needed. It's not only pilots that are needed. There are also a lot of lawyers needed to take this field forward, and also to ensure that aviation reaches its full potential by exploiting all the opportunities that are available, as Dr. Abhiratna mentioned, with quantum computing and various other new technologies that are available. So we have to take this opportunity. And one of the main reasons that I would like to present this topic with a local flavor is to encourage most of these young lawyers to get into this sector and look at the possibilities. The state regulator in Sri Lanka is the Civil Aviation Authority of Sri Lanka. Now, the state regulators specialize international governmental organizations like the International Civil Aviation Organization, which is referred to by the acronym of ICAO, as well as international non-governmental organizations such as IATA, the International Transport Association, at varying levels make rules and regulations to govern national as well as international air transport. These rules and regulations have multifarious effect and approaches, and inter alia cover many matters such as safety, security, economic regulations, airline liability, security interest in aircraft, and many other facets connected with civil air transport. International regulation relating to air transport can be considered in two broad perspectives. One, through the lens of public international air law, and the other, private international air law. Public international air law principles are mostly derived from multilateral international treaties and conventions, as well as customary rules. And this public international air law envisions the regulation of conduct, obligations, and rights of states vis-a-vis other states, where the rights are enforced against states at that level. Whereas private international law, on the other hand, regulate the conduct, obligation, rights, and duties of individuals, bodies, companies, corporates within states, such as consumers, airlines, and their rights are determined by international, private international air law. As I mentioned, the cornerstone of public international air law is considered the Chicago Convention of 1944, which was brought into effect immediately after the Second World War. And this was given effect to in Sri Lanka by the Air Navigation Act number 15 of 1950. The current statute of Sri Lanka, which governs civil aviation, which has given effect to the provisions of the Chicago Convention, is a Civil Aviation Act number 14 of 2010, which repeals the Act of Air Navigation Act number 15 of 1950. Now, in between the initial Air Navigation Act of 1950, there were several other conventions and treaties to which Sri Lanka adhered and were given effect to, which I will briefly refer to as a Tokyo Convention of 1963, which related to the offences and other acts committed on board aircraft. The International Convention signed at Hague in 1970 for the suppression of unlawful seizure of aircraft. I recall this particular convention was given effect to in Sri Lanka around the year 1982, after there was a hijacking incident where, if you may recall, there was an individual named Sepa Lekanayaka hijacked an Alitalia aircraft and brought it to Colombo. Unfortunately, Sri Lanka had not at that time ratified or given effect to this convention, and therefore, after the incident, laws were promulgated and legislation was introduced to give effect to this convention retrospectively, so that the offender was punished, although the law was enacted after this incident. Then, of course, there was a Montreal Convention of 1971 and its protocol of 1988 to prevent or suppress unlawful acts against safety of civil aviation, as well as unlawful acts of violence at international airports. So these are some of the conventions, the principles of which have been given effect to in Sri Lanka. And some of these principles have also been reflected to in the Civil Aviation Act of 2010, 14 of 2010, particularly with regard to offences on board aircraft, where incidents having the flavor of air rage or where passengers cause trouble in the aircraft to other passengers or the crew, they can be punished. And these principles have been enshrined and enacted as law in Sri Lanka. Now, there are also several private international law treaties that have been given effect to in Sri Lanka. The first is a Warsaw Convention, which relates to the liability of airlines for carriage of passengers, cargo, and goods, which was originally signed in 1929, which is known as the grandmother of all conventions, and that was given effect to in Sri Lanka in the 1950s. And its amendment, the Hague Protocol, was given effect to by Air Navigation Special Provisions Act number 55 of 1992. All of these were updated with the advent of the Montreal Convention of 1999, which largely contained the structural features of the Warsaw system, but did some changes with regard to some principles of liability limitation, etc. And this convention was also given effect to in Sri Lanka in the year of 2018 by Act number 29 of 2018, the Carriage by Air Act, which has now made the Montreal Convention a part of the Sri Lankan law. I just referred to these as some of the conventions and laws, so that mainly to make the audience aware of these provisions, which they might have known, might not have known. At this stage, for the ease of understanding, I will try to simplify the main parties involved in the supply and consumption of air transport services. On the one side, you have the airline, which is the supply of air transport services. On the other side, you have the consumer, the airline consumer or the passenger or the shipper of goods, who is a user of these services. And thirdly, and the other important key player in this supply user chain is a regulator. Which regulates the industry, regulates the air transportation services. Now, there are also a host of other persons, intermediaries, as well as stakeholders who supply services, goods to the airline industry, like the air navigation service providers, the facilitators, the ground handling services, catering, fueling. All of these are essential services for air transportation services. But for the moment, I will focus on these three main parties in this supply and user chain of air transportation services. The regulator in the Sri Lankan context for civil aviation is a Civil Aviation Authority of Sri Lanka, which has been established by an Act of Parliament, number 34 of 2002, to regulate the conduct of civil aviation within the territory of Sri Lanka. It is a national authority performing the functions of regulation and supervision, as well as oversight of airline industry within the country. It formulates national aviation policy. It's a national agency responsible to ensure that international treaties and laws governing aviation are implemented and followed within the country. It also regulates and supervises all ancillary service providers in the airline industry. For example, it licenses and supervises airports, aerodromes, ground handling services, catering, air navigation services, travel agents, and other service providers in the industry.
I'm sorry to disturb you, sir. You have also 5 minutes.
All right. Then I also wish to mention about the airlines. The airline consumer is a part, the airline is a party that operates a flight, must obtain a license to operate these flights, and also has to comply with the host of rules and regulations to be able to operate such flights. Then we have the airline consumer, which has the least amount of bargaining power in this transaction and has to be given protection. Now, I would like to see what are the opportunities that are available for a local lawyer in the scope of activities which I explained or described. Now, under the regulatory scheme, you have licensing. You have disciplinary matters relating to pilots, airline professionals. You have regulatory oversight, which can attract the scope of administrative law and judicial review, where the regulatory authority has failed to issue a license or delayed to renew the license or impose disciplinary punishments on persons who are licensed under the authority, air traffic controllers. All of these come under the licensing and supervisory authority. And you can also advise a number of foreign airlines regarding applicable rules and regulations in Sri Lanka. The opinions with regard to what happens to an foreign airline when they have to come to Sri Lanka and operate. The economic regulations applicable in Sri Lanka, which is all available in statutes and regulations. Then on behalf of airlines, a lawyer can draft and interpret agreements. There are multifarious agreements. Airlines will have ground handling agreements, service agreements with caterers, fuel supply, a host of agreements. There are even agreements where the airline enters into with beauty salons to ensure that their cabin crew get proper makeup and things like that. So these agreements, these are all formulated by way of agreements. And then you also have a lot of litigation where you can represent airlines and advise airlines. Then the primary area is a passenger claims, where the most common area for litigating lawyers, where they engage in passenger claims for denied boarding, lost baggage, injuries, aircraft accidents, and so on. There's tremendous amount of work in those areas. And it is opportune for a lot of young lawyers to equip themselves with this knowledge and move into these areas. Then I think because of the passenger claims takes an important role, I would like to mention about the passenger claims, which are now governed by the Montreal Convention in Sri Lanka, which is applicable to all passenger carriage, which is applicable to all international carriage to and from Sri Lanka, based on the principles set out in the Montreal Convention. Now, this convention in our local lawyers' language gives a special benefit to a passenger, where in the case of damage or injury or loss of baggage, you have no burden to prove negligence on the part of the airline to establish a claim. All you have to do is prove that the damage or injury took place on board the aircraft or in the course of embarkation or disembarkation as a result of an accident or incident that occurred on board the aircraft or in the course of embarkation or disembarkation. So we are used to the rule of evidence in court, where the principle is he who asserts must prove. In a motor accident, we would have to go to court and prove that in fact the driver of the vehicle was negligent when the accident was caused. Although the principle enshrined in the Montreal Convention, on the other hand, is something similar to the res ipsa loquitur rule, where the mere occurrence of injury or damage being sustained as a result of any incident that occurred on board the aircraft is sufficient to impute liability on the airline. When you impute liability on the airline up to a sum of 128,000 SDR, which corresponds to about 430 rupees at 430 rupees per SDR, is a special drawing rights, which is a unit of currency used for international monetary transactions. The total aggregate value would correspond to about 55 million rupees today. In the case of death, a passenger death or injury, all you have to prove is that the death occurred as a result of injury or a result of an incident that occurred on board the aircraft or in the course of embarkation or disembarkation. And then up to that value, up to 55 million, you have to prove your damages. The airline does not have a right. It is a form of a strict liability to forward a defense. The airline has to then compensate you. If the airline does not voluntarily compensate, you can seek the compensation in court. As I said, there is no burden to prove your liability, negligence on the part of the airline. All you have to prove is that the damage has occurred. Of course,
sorry, sir, time is up.
Right. I will probably advert to some of the examples of liability in the course of panel discussion. And thank you very much for the time.
Thank you very much, Dr. Asante Hettiarachchi, for enlightening us on fundamentals of air law and, of course, the Sri Lankan legislation on air transport. Now we move to the panel discussion. I will put some questions to both the speakers. First, I'll ask from Dr. Wanku Saberatna, and then I'll move to Dr. Asante Hettiarachchi. Right. So the first question is actually Dr. Aberatna. Now that you have mentioned a lot about technological advancements in the industry, within the next 2 decades, we'll see a lot more of this happening in reality, from quantum computing to autonomous aircraft, electric aircraft to AI integration, likewise. And of course, the manufacturers have started investing rather heavily on these research and development programs. But of course, at the same time, we have seen the manufacturers trying to bypass the regulations. The best example, as you mentioned, is the Boeing 737 MAX 8 issue. The congressional investigations revealed that how Boeing concealed the relevant facts from Federal Aviation Authority. And in that scenario, so how do you think that the laws have to align with these developments, not allowing manufacturers to play up? Sir?
Sorry for the delay. I was trying to unmute myself. Now, that's an interesting question. So I should start, I think, by saying that the laws and regulations are there. Now, I just take one example. Anusha mentioned 737 MAX 8. Now, there, Annex 8 to the Chicago Convention, which is on airworthiness, has specific provisions which were not followed, in my view at least, for whatever reason. Reasons have been given in terms of the expeditious manufacture of aircraft or the lack of inspectors or whatever it is. But Annex 8 clearly says that it is the aeronautical authorities or the state which should certify an aircraft. Now, you cannot put that burden or delegate that authority to the manufacturer itself. And the manufacturer certifies its own aircraft. So there are checks and balances which, if they're followed to the letter, it's sort of gives some guarantee that particularly manufacturing of components and that kind of thing, some degree of safety. Now, having said that, the challenge, the problem, and the inherent, I would say, anomaly in this whole thing is that Article 37 of the Chicago Convention says states will get together and in all cooperation, in their best endeavor, adopt standards and recommended practices in these various areas. Annex 90, 1 to 19. 1 is personnel licensing, 2 is rules of the air, 3 is meteorology, and so on. Article 38 says, however, if it is impracticable, that means impossible to follow these, you can just inform the International Civil Aviation Organization. So now anybody can say, I'm sorry, even Annex 8, it's impracticable with all the huge manufacturing going on and the lack of inspectors and all that for us, the Federal Aviation Authority or whoever the aeronautical authority, to ensure that we certify. Therefore, we can hand it over to a party whom we trust. So that probably is the most anomalous thing in the Chicago Convention. There is only one exception, of course, Annex 2, rules of the air. Whether you like it or not, you have to follow it. Otherwise, planes will fall off the skies. So from north to south, east to west, airlines have to follow the rules, the rules of the air there. And Article 12 of the Chicago Convention says very clearly, when you're flying over the territory of a state, you have to abide by that state's laws. And if you're on the high seas, you have to follow what is said or developed by the convention, which is Annex 2. So now, it's a very difficult situation to ensure all the time these things happen for another reason, and that is competition. And competition, again, there are competition laws domestically and all that, but when a supplier of goods and services competes with another supplier, without naming names, the manufacturing process, the supply process could have certain deficiencies or certain processes which are not acceptable. So, well, that's what I can think. There is no sort of hard and fast rule that will ensure total immunity from this. I hope that answered the question.
Thank you, sir. In fact, that was the competition that resulted in that between Airbus and Boeing that resulted in the issue Boeing 737 MAX 8. Dr. Hettiarachchi, do you want to contribute?
Well,
Okay.
I think a very comprehensive answer was given by Tissa, and I don't want to take more time.
Okay, so thank you. And my second question is also for Dr. Abhiratna. This is about cyber security, sir. You have actually, tried to elaborate on cyber security and the applicable law. This is new normal for air transport. Anyway, now all the traditional actually aviation security law conventions Dr. Hettiarachchi mentioned, we all speak about physical actually attacks or physical interference, physical unlawful interference with civil air transport. But except for Beijing Convention, other conventions do not actually cover cybersecurity. So what has been done so far, sir, apart from the Beijing Convention, even by the ICAO, to address this issue? Because this is something that can happen from any point in the world, cyber attacks.
Well, the thing is that there are lots of things that have happened across the world in terms of cybersecurity. For instance, Eurocontrol has pronounced on cybersecurities and introduced cloud 5G, internet, satcom, nav, and so on. You see, the problem with cybersecurity is that it has a lot of threats, geopolitical. Then there is cybercrime, hacktivism, aviation's vulnerability to a patchwork of systems, and so on. And I must mention a couple of things that actually came to light. And this was the New York Times on the 2nd of May published an article where a serious allegation from the Republic of Korea, South Korea, that the Democratic People's Republic of Korea, that is North Korea, was sending out signals that were calculated to jam civilian and military air traffic navigational systems. Now, this is called exogenous interference from outside. And whether or not that was proved is another matter, but this matter was taken up in the Council of ICAO. I remember I was working in the legal bureau when the Korean delegation, South Korean delegations came and talked to me and said, what can we do about it? And I said, write a council paper. I think they did, and it was taken up by the council. And of course, where diplomatic language goes, which ICAO is famous for, there was a general statement that states must refrain from using extra measures or exogenous measures and so on. But the thing about cybersecurity is that, again, one of the things that strikes me is that now the Beijing Convention very clearly, as Anusha mentioned, brought in this provision, and this provision, I can read it out. The original provision on the safety of aircraft says, any person who interferes with the operation, blah, blah, is guilty of an offense. Now, the protocol to the Beijing Convention says any person commits an offense if that person unlawfully and intentionally seizes or exercises control over an aircraft in service by force or threat thereof, or by coercion, or by any other form of intimidation, or by any technological means. Now, that last thing, technological means, is what brought the cybersecurity aspect into the Beijing Convention. Now, the Beijing Convention has entered into force. Now, the thing is that I must make mention of that fact, and Lasantha can correct me on this. Sri Lanka has not yet ratified the Beijing Convention. So, I just mentioned it because I went into the ICAO archives and this is the information I got. And is correct?
Yes, sir. Yeah,
yes,
that's correct.
Okay. So now, one of the things now, again, while we are at it, Sri Lanka, my experience in ICAO has been that ICAO has been extremely impressed with Sri Lanka's record. That's both in security and safety. The universal safety oversight audit, Sri Lanka has scored very high, and I've been told this officially. So Sri Lanka's reputation is excellent. Its ratification of treaties has been very good. There are only two exceptions that I can see. One is the Beijing Convention ratification. The other, and that also is essential, Lasantha mentioned the Tokyo Convention of 1963, which is offenses committed on board the aircraft. And in 2014, there was a protocol to slightly amend this Tokyo Convention, and that protocol brought in additional jurisdictions that an offender can be charged, like the state of registration and the manufacturer and so on. The other thing is that the aircraft commander can request the in-flight security officer to help him in restoring, quote unquote, discipline and good order in the aircraft. Now, that has also not been ratified, as far as I understand, by Sri Lanka. These are the only two instruments that I can find that Sri Lanka has not yet ratified, and it would be good if it ratifies those, because of the evolution and deflection of time that takes to develop aviation. And Sri Lanka now has a good system of aviation, 23 aircraft flying all over the place, connecting and all that. So that would be good, I think.
Thank you, sir. And of course, adding to that, and of course, if I mention the list of the conventions and protocols where Sri Lanka is yet to become a party, includes the Beijing Convention of 2010, Beijing Protocol of 2010, Montreal Protocol of 2014, and the Montreal Convention of 2009 on surface damage that modernizes the Rome Convention of 1952. So
Right.
now that we have attendees from, I think, the BASL, Attorney General's Department, Civil Aviation Authority, please actually urge the government to ratify these or accede to these conventions and protocols as soon as possible. Dr. Asante Hettiarachchi, want to contribute? Dr. Asante, yeah.
Yes, thank you, Anusha. I think you covered the list of instruments that are to be ratified. As you say, it is important that we move forward with the ratification of these conventions.
Okay, so now I have a question for both of you, sir. First, I'll start again with Dr. Tissa. Now, in terms of breaches of Chicago Convention of 1944 by Belarus, North Korea, and Russia, at the 41st Assembly session of ICAO, actually there have been resolutions passed, as you said, sir, condemning these attacks. What more the international community could do, legal-wise and otherwise, to actually prevent these types of breaches in the future?
Good question, Anusha. I don't know whether I have a answer to that which would be credible and applicable as such, because all this is very geopolitical. And I mean, in the case of Belarus, you know, Ryanair flight from Athens to Vilnius in Lithuania was diverted to Minsk in airspace Belarus, while on airspace of Belarus, on the pretext that there was some safety concern and safety of the aircraft was threatened and to land in Belarus, but actually it was to arrest a passenger on board and his fiancée who were traveling. Now there, the thing is, it becomes a very legal argument, because the legal argument is, again, you go to the preamble of the Chicago Convention, which I mentioned, it says safe and orderly development of air transport, which was not the case here. And what the Assembly pointed out was that Article 4 of the Chicago Convention says civil aviation should not be used for any purpose against the provisions of this convention. So the provision of the convention was safety, and the condemnation was that it jeopardized and compromised the safety of the aircraft and passengers for no good reason. So now, again, you go back to Article 1 of the Chicago Convention, which says states have sovereignty over the airspace above its territory. And Article 2 says, well, territory means the land mass and the territorial waters, which is 12 nautical miles surrounding the country. And you can do anything that you please as a state authority or the state. So if you want to claim that you are worried for the safety of an aircraft above your territory, which comes in your jurisdiction, you can say on suspicion we did it. But the way they did it was they sent a fighter plane and escort the plane and all that was the problem. That's Belarus. But of course, there was Russia, 2 resolutions on Russia as well as North Korea, which were 2 different things anyway.
May I also add
Of
my
course, yeah. So because Dr. Asante Hettiarachchi had a very practical experience last year of the Russian issue, especially the Su-289. I think he appeared for Aeroflot, if I'm correct. Please.
I will not refer to that particular thing, but in general, what I would say is that this read out at the beginning the preamble of the Chicago Convention, where it says that it's desirable to avoid friction and promote that cooperation between nations and peoples upon which peace of the world depends. And therefore, the undersigned governments have agreed to certain principles and arrangements in order that international civil aviation may be developed in a safe, orderly manner, and that international air transport services may be established on the basis of equality of opportunity. Now, what precedes the development of safe and economical air transport is that it is supposed to promote cooperation and to avoid friction. But unfortunately, what we also see is that at international fora, particularly the ICAO and various other international organizations, these assemblies or these bodies are being used by different states with different ideological leanings, and civil aviation, unfortunately, is not being used to promote peace and amity amongst nations, but more as a tool of ideological warfare. Very simple example is where people use sanctions on air transport. When you impose sanctions on air transport in a situation where two different states are at war, and then a whole host of other countries supporting one side or the other imposes sanctions. And that leads to other complications. Now, in the case of Russia, it closes its airspace. Then also it has been used in the Middle East, where several countries prevented their airspace being used by Qatar. So these are, in my view, they run contrary to the principles that are enshrined in the preamble of the Chicago Convention. On the other hand, we also must be mindful of Article 89. It says, in the case of war, the provisions of this convention shall not affect the freedom of action of any other contracting states affected, whether as belligerents or as neutrals. So you don't have to comply with the provisions of the convention in the event of war. So there are ideological differences, but they should not be brought into the field of aviation, because that conflicts with the entire basis of the convention and the thoughts of its drafters, that you wanted to promote peace through the Chicago Convention and mutual cooperation towards uniform, commonly pursued goals of all states for the benefit of everyone.
Okay, sir, thank you. And I have a question to you again, sir, Dr. Hettiarachchi, on passengers' rights. I think all are actually familiar with these problems of delays. As Dr. Abhiratna said, it's actually very frequent in even countries like USA, Canada, likewise. So, sir, about these passengers' delays, overbooking and dumping, even the Warsaw Convention of 1929 and even the Montreal Convention of 1929 does not provide for, they do not provide for liability levels for delays. And those are domestically decided, and EU has their own regulation 261 of 2004 on passengers' rights, and that covers delays. What can't we have an international actually regime on this? What are your thoughts on this, Dr. Hettiarachchi?
Well, in the Montreal Convention as well as the Warsaw Convention, there was the provision of delays was covered in the liability being imposed upon the airline. It says the airline is liable for damage sustained in the case of death, bodily injury of a passenger, or in the event of delay. I'm reading death or bodily injury of a passenger if the accident which caused the death or bodily injury took place on board the aircraft or in the course of any of the operations of embarkation or disembarkation, and the same liabilities imposed also on the airline in the event of delay in terms of Article 18. Article 19. The carrier is liable for damage occasioned by delay in the carriage of air of passengers, baggage or cargo. So there is damages for injury or death, and then damages for delay. So denied boarding has not been specifically addressed in the convention. However, denied boarding will result in delays. So in the event of delay, there is damages of 1,288 special drawing rights, which approximately is 555,840 rupees at today's value in the event of for delay. So we don't, now there have been several countries which have brought in domestic laws addressing denied boarding, delays, where a certain amount of delay, if it's 3 hours, a certain amount of compensation. If it goes beyond 6 hours, there's an obligation to provide food and some facilities to the passenger to make phone calls, and also provide accommodation if it exceeds, and or a certain payment. So those have been brought in by certain countries. There's criticism that this departs from the principles of uniformity that was pursued by the international community, where they wanted to have similar levels of similar rules applicable universally. So for the moment, if you look at Sri Lanka, denied boarding and similar situations have to be addressed on the delay. And if you prove that you have suffered damages as a result of delay, you can certainly claim compensation in court.
Ranshi, and we have actually a lot of questions to discuss, but I think we have 10 questions coming from the audience as well. I have one last question to you, Dr. Hettiarachchi. It's about, now that you have covered a lot of things in your presentation and the answers, in terms of actually lawyers here. How important is it for lawyers to be trained and exposed to be specialized in the field of air law, relating to our lawyers in Sri Lanka? Any advice we can give?
Yes, I think we have had a separate discussion where Tissa has always been on many occasions saying the importance of having more lawyers in this field. And in particular, he referred to the resolution of the 41st Assembly, where they wanted to, where the states have collectively agreed to improve the knowledge base and have legal advisors trained worldwide to supplement and also improve the legal and professional services available to the industry in this regard. I think from a Sri Lankan perspective, it is the lack of awareness that has mostly not attracted a lot of, particularly the young lawyers, lack of awareness of the opportunities, and also the interesting spheres that can be covered, both in the public regulatory sector as well as private sector in advising airlines and also representing consumers. So I think it is very important and it's timely that more information is disseminated, and perhaps the Bar Association itself can get involved in creating some pilot programs for more focused training. And I know Tissa has on several occasions volunteered to provide his expertise and guidance to this. I would also be more than happy to collaborate and also assist him if the Bar Association takes the initiative. And we should have more people trained in this sector to make use of the opportunities that are available.
A very quick interjection, if I may, very quickly. Imagine I am asked by the Sri Lankan authorities, why should we teach aviation law to lawyers? My answer would be just very simple. This is an area of the law which is different from any law you know on the ground. I sort of mentioned it at the outset, how it is different. I will just give one example. In Olympic Airways versus Hussein, a passenger was traveling from Athens to New York, and you know the cases, the lawyers here. And he suffered acute asthma. He was an asthmatic by ingesting smoke, which came from the smoking compartment at that time. He asked for a non-smoking seat. He was given a non-smoking seat just behind the smoking seat, and he died. And the Supreme Court of the United States handed down its decision. And the basic argument was, Lasantha mentioned that the carrier is liable for damage sustained in death or injury if it happens on board, if the accident which caused the damage occurred on board. Now, here, the word accident on the ground is you are hit, you are harmed. Here, the interpretation was up in the air 40,000 feet. An accident is the failure to provide medical assistance is also an accident. So you can see that there are nuances which domestic law or law on the ground, criminal law, delict, tort and all that, don't necessarily comport with. So this is a completely different area of the law. It not only will give, as Lasantha says, lawyers the exposure and reach of aviation law, but they will expand their minds for more analysis and so on.
Thank you, sir. Now, yeah, I'm sorry.
If the moderator allows me a little bit of time, so I can give some examples more than anything, particularly for practicing lawyers to evoke interest in them. When we mention accident which caused, accident or incident which caused, must be deemed something that is not inherent infirmity of the passenger. Now, the case of Air France versus SATS, it was where damage was suffered by a passenger to the eardrum because of the depressurization in the aircraft cabin. And the Supreme Court of the United States held that accident could not, the airline can't be held liable because that was not something that was a matter which was external to the operation or the normal operations of the aircraft. So it was something inherent where the passenger had a problem and eardrum was damaged, but the airline was not held to be liable. Similarly, there was a series of cases which is called DVT, or the deep vein thrombosis, where people suffered, some of them died, some of them had severe illness because of being confined in the aircraft and blood clots forming in their body or traveling to the heart. Some of them died. So here again, the courts have held that the airline cannot be held liable. There was a case of Wallace versus Korean Airline, where the court found that an act of a sexual predator who fondled a underage plaintiff while she was sleeping was not something that you could impute liability on the airline. Then Tisa mentioned Olympic Airways. Now, what exactly is on board the aircraft? Or now, for you to qualify to be able to recover damages from an airline, you should be able to prove that the incident or accident occurred on board the aircraft or in the course of embarkation or disembarkation. There was one case which involved Swissair, where an aircraft was hijacked. And for 7 days, the aircraft was landed in Jordan, Amman, and it was kept for 7 days by the hijackers, who eventually released the aircraft and the passengers, and they flew to their final destination. Now there, the courts held that their entire time they were being hijacked, and entire time they were under the control of the hijackers, was still deemed to be being on board the aircraft, which in turn made the airline liable. Then you have what is embarkation and disembarkation. What is in the course of disembarkation? There are people who have suddenly fallen when they deplane and go to collect their bags from the airport at the baggage carousel. There, the airline has been held not to be liable because it was too far removed from the general operation of the airline. There are cases where terrorists attacked an airport while the passengers had done their checking in. done security clearance, and then moved to an area which they were confined to, and the terrorists attacked the aircraft and a couple of people died and some of the persons were injured. There the court said, although you had not embarked on the journey as yet, you were under the control of the airline, and it imposed something called a control test to see how much of control does the airline exercise over you. So you don't have free movement to go where you want. You're confined to an area. So you were deemed to be in the course of embarkation or the operations leading to the embarkation. So there are a series of cases where you're at the control. And there was one case, an interesting one, where it's called Bloch versus Air France, where airline, there was a lot of construction work going on at the Paris airport, and when the passengers got off the aircraft, the air hostesses led them. They had to walk across the tarmac, the airport to the passenger terminal, because construction was going. They had to follow, all of them had to follow on a particular line. And one of these passengers, he decided it was short, he could see the terminal without following the path that the air hostess was leading them. He decided to go on his own and ended up falling into a concrete pit, a big pit that was made in the at the airport. And he was of such big proportions, he didn't fall through it, he got stuck in it, and they had to bring concrete cutters and various implements to cut the concrete and extricate him, in the course of which he suffered extensive damages. Although he tried to argue that this was in the course of embarkation, the courts held that he was not under the control of the airline because he had gone on his own, and he was therefore not allowed to be compensated. So these are some of the examples. In Sri Lanka, we have had cases where, with regard to the Thai protests and the airport being taken over by the protesters, before the passenger got into the aircraft, several flights going to Bangkok had already been cancelled and it was on the board. And the passenger inquired from the airport staff whether it would be safe for him to fly through Bangkok. He was connecting a flight onwards to China. And he was assured that there is no problem. And passenger, in fact, got in and he couldn't deplane. The aircraft was diverted to a different airport in Thailand. And he was stuck in Thailand for almost 1 week, and he couldn't return to Sri Lanka, nor could he go on his business journey. There, the court held that the failure to either reroute the passenger on another route or to prevent the passenger from taking that flight which could not go to its destination was the accident which gave rise to liability on the part of the airline. So there are numerous examples, and it's a very, very interesting area where lawyers can get involved and can make many interpretations and take this area forward.
Okay, thank you, sir.
Can I quickly add very quickly to what Lasantha said, which is absolutely correct. So the courts did not know what to do in all these instances. They formulated what is called the tripartite test. That is three-pronged. LAC, you remember, location, activity, and control. Lasantha mentioned control. So location, if a passenger checks in and then wards off to a Starbucks to have a coffee, what was his location? Was it relevant to the journey and so on? And activity is what was it relevant to the journey itself? And the control, good examples are given by Lasantha, and control of the airline is even on a journey, say, from Montreal to Doha onwards to Indonesia, which I did, and I had to, Qatar Airways gave me a bus to take me to their hotel, and to get the connection the next morning, I was still under the control of the airline. Now, where it comes to disembarkation, people ask, what is the disembarkation? Is it when you get out of the aircraft, when you are walking towards immigration, or when you walk out of the airport? And now the norm is, accepted norm is, the disembarkation ends when you pick up your baggage. So up until the time the airline delivers your baggage, you are under the control of the airline. That is what is generally followed, but of course the courts can always say different things. Just thought I'll add that.
Okay, so thank you. Now we have questions from the audience.
And for local lawyers, I think most importantly, they must be mindful of the principles of jurisdiction and where you can sue, and particularly that it's not, we can't go to court and rely or formulate the cause of action only on contract or tort law that is applicable in our courts. But the convention says whether you sue under contract or you formulate on the basis of tort, you are governed by the rules of the Montreal Convention, because the convention cause of action is exclusive and it is governed by all the rules, limitations that are formulated in this convention. And there have been occasions. So it's important for the parties to know when you sue, which court can you go to. One example here is there was a KLM versus Anil Tittawala case where was a case of denied boarding and case where damages were sought, filed in the District Court of Colombo, and it was argued that this was a commercial transaction because the damages at that time, this was in the 90s, was in the range of about 50 million or whatever, and it was argued it should go to the commercial high court. And the district court did hold it should go to the commercial high court, and against that decision an appeal was preferred. Court of Appeal held that it was in fact a commercial transaction. Of course, in today's value, commercial transactions over 50 million have to go to commercial high court. But if your transaction is less than 50 million, you can still sue in, if your damages are less than 50 million, you can sue in district court. But otherwise, you have to go to commercial high court if you are seeking damages beyond 50 million, because the Court of Appeal decision, although it was appealed to Supreme Court, was settled before Justice Sarath Silva, and there was no pronouncement made whether an air transportation transaction was a commercial transaction. I would, of course, my personal view is that air transport, like any other passenger transportation, motor transport in a bus or train, would not fall within the strict purview of a commercial transaction, because it's only a contract to transport one person from place A to B. But nevertheless, a law as it holds, as formulated by the Court of Appeal, is that it's a commercial transaction. So you have to sue in the commercial high court if it's over 50 million. So just there are lots of areas that can be gone into. Unfortunately, due to the constraints of time, we will have to confine it to whatever.
Thank you, Dr. Hetera. I'm extremely sorry. I was actually a bit concerned about the time, but we still can take a few questions. One question is actually posed by Mayuka Ranasinghe. This is to Dr. Abeyratne, sir. The imbalance of, I will read out the question. The imbalance in aircraft leases was one of the causes that adversely impacted airlines during COVID-19. Some airlines had to seek relief under restructuring mechanisms to overcome lease obligations or to put themselves into liquidation. These events undoubtedly impacted on economic interests of the international air transportation. Is there any room for ICAO to step in to protect interests of airlines in instances of this nature under Article 44 of Chicago Convention in the interest of international air transportation?
Thank you. I hope I can be heard. Now, Article 44 of the Chicago Convention gives the aims and objectives of ICAO, which are to develop the principles and techniques of air navigation and to foster the development of air transport. There's a distinction there. principles and techniques of air navigation means those are mandatory rules to be followed, like rules of the air. But ICAO can only develop fostering of air transport, economic aspects of. So fostering does not mean ICAO can tell states what to do. Number two is ICAO's purview. It's a club of states. It doesn't look after airlines as such, and that is the association called IATA, which is the club of the airlines. So ICAO, the Chicago Convention established ICAO to look after the states' interests, and both the mission and vision of ICAO is that it is a forum for states to get together and formulate principles. So when the airlines are in distress, or when the airlines have problems on leases and so on, it is not the purview of ICAO. Sorry, I lost my voice there. So I would not think that ICAO should take the initiative on that. It's purely an organization of states. It's a specialized agency of the United Nations, which looks after states.
Thank you, sir. I think this answers your question, Maika. And we have a question from Mr. Senaratli again. So this is to Dr. Rasatha Hettiarachchi. I'll read out the question. You mentioned about recovery damages by passengers under a strict liability regime up to the convention limits. The preamble of the Montreal Convention states it should be equitable compensation based on the principles of restitution. Is this applied in cases in Sri Lanka?
Let me put it this way. I have seen on numerous occasions when people formulate actions in court, they just look at the liability limit and they think we are entitled to recover this amount merely because you're entitled to recover on strict liability up to that value. That is a wrong perception. The entire concept of recovery of damages is still based on restitution, which restores you to your original status quo. So if you have suffered damages, if a person has died and the family has lost a breadwinner, you would have to prove what your damages are in court, and you are entitled to recover those damages. And when you refer to strict liability will be, the airline will be liable to pay those damages without any right to a defense in the event those damages are below the limit of liability that is stipulated in the convention. So the liability limit that is currently applicable for death or bodily injury is 128,000 special drawing rights, which corresponds at 430 rupees a special drawing rights at today's value to approximately 55 million rupees. So as long as the damages that you claim are below the value of 55 million rupees in the event of death or bodily injury, or in the other instances, as I mentioned, for damages for delay, there is a value. Damages for loss of baggage and cargo, there is a value. So as long as those values are below those stipulated limits, strict liability will apply and the airline would not be entitled to mount any defense. Now, if the liability limit is to be exceeded, if you're going to claim 75 million in the event of a death, then of course the airline becomes entitled to prove that the damage occurred due to contributory negligence, or that it was beyond the control, or all necessary measures had been taken by the airline and the damage was not something that the airline can be made responsible. So those defenses come in if the amount of damages that are sought. But the underlying principle is you're not automatically entitled to recover the amount that is given, but you have to prove the quantum of your damage. You don't have to prove negligence by virtue of the Article 17, Article 18, and Article 19 of the Convention. The airline is liable on the occurrence of the damage, but you have to prove the quantum of the damage to recover. Does that, I hope that answers the question.
Thank you, Dr. Hettiarachchi. And there's a question coming from Mr. Rehan Wanyapa. And of course, before the question, of course, he has informed us, he says, Anusha, Civil Aviation Authority of Sri Lanka has commenced process to accede to the Cape Town Convention, Beijing Convention of 2010 and MP14. Thank you very much, Mr. Wanyapa, for informing us. And the question goes to Dr. Aberatna. The aviation industry collects huge number of data, sets of passengers, and facial recognition may be the norm in the near future at most international airports. What do you think would be the future of regulating the privacy of these data sets in international civil aviation? Dr. Aberatna and Dr. Hettiarachchi both can answer, I think.
Yeah, that's a very interesting question, because it so happens that IATA requested the legal committee of the of ICAO to consider at the 38th session of the legal committee in 2022 the subject of privacy of airline passengers as a future area of discussion in the legal committee's agenda. Now, the IATA working paper elaborate that although many aspects of liability and regulatory regimes of international civil aviation organizations are unified or harmonized, this aspect isn't. So the subject was discussed. IATA was concerned that in international air travel, where a passenger crosses several borders, it was incontrovertible that the passenger's personal data would be transmitted beyond the point of origin of the travel, and it was necessary to protect. Now, in terms of the regulation, this comes under Annex 9, and we are talking about digital identification and so on. This standard 3.1 of Annex 9 provides that in order to facilitate and expedite the clearance of persons entering or departing by air, contracting states must adopt border control regulations appropriate to the air transport environment and shall apply them accordingly. 3.3 of the Annex provides that states using integrated circuits or optional machine-readable technologies for the representation of personal data, including biometrics, in travel documents must make provision whereby the encoded data may be revealed to the holder of the document upon request. And there are so many other aspects which are covered, which are calculated to protect the interests of the passenger. And even globally, OECD and various other organizations, including the European Union, now have fairly strict privacy regulations.
Thank you, Dr. Aberatna. And Mr. Senrat Lienage has added a comment. Dr. Hettiarachchi, he says, I ask this because the Carriage by Air Act number 29 of 2018 doesn't have this provision. The preamble is missing, like that means in terms of, I think, yeah.
Thank you.
Compensation.
I thank Senarat, my colleague and friend, for pointing that out. I agree with him. Only thing is, what we have to understand is that it's an international convention. Sri Lanka has ratified and brought enabling legislation to give effect to it. And there may be some drafting deficiencies in adopting the convention. But in principle, having ratified it, there is legislative intent that is shown of that the legislature wanted to give effect to this in Sri Lanka. And if there was the principle that was laid down by the by Lord Denning in Corocroft versus Pan American Airways, it says that Warsaw Convention, of course, it related to the Warsaw Convention, but it's also analogous to this situation. It's an international convention which is binding in international law on all countries who have ratified it. So the duty of courts is thus to construe domestic legislation so as to be in conformity with it, with international law, and not in conflict. So in the event there are some ambiguities and this comes up in court, my personal view is that there is an obligation on the courts to give effect to the principles that are enshrined in the convention and to make our domestic laws, even if there is a deficiency, consistent, interpreted consistently with the international convention principles. I'm glad that Senrat has pointed out, but This would be my response to that question.
Thank you, Dr. Hettiaraj. There's a question from an anonymous attendee. This question goes to Dr. Asantha. Can you briefly explain the Aeroflot airline case litigated in last year, 2022? And could you also, okay, the second part is already answered. Could you also explain why Sri Lanka is not yet a party to most the crucial aviation-related international conventions? The answer we got. Would you want to
Let me put this.
answer?
I will not go too much into the factual details, but what I mentioned earlier is that ideological differences. Now, the Aeroflot case, what transpired is there is a lease agreement entered between Aeroflot and a party in a different country. The lessor, the owner of the aircraft, was in Ireland, leased the aircraft to Russia, and that aircraft had been operational for over 20 years. Under the same lease agreement, several aircraft have been given. So it had gone on for a long period of time. And when the Russia-Ukraine war erupted, Europe and America imposed sanctions and asked all the airlines, as well as air transport, as well as aircraft owners, not to lease aircraft to Russia. Now, what they did was they immediately asked the Russian airlines to return the aircraft, which they refused. And these aircraft had been registered in Bermuda, several of these, and they were subject to what is called Article 83 bis registrations, where regulatory oversight was conducted by Bermuda under certain agreements. So when Bermuda was instructed by the owner without cause, they terminated the Article 83 bis agreements, saying that they are no longer willing to accept the registration certificates issued. So then they were asked to be deregistered from Russia. They deregistered these aircraft from Russia, from Bermuda. And then what Russia did was it created its own registry and it entered all these aircraft into its own aircraft registry. Now the Chicago Convention says that an aircraft can be registered only in one state at a time. You cannot register it in another state when it is already without deregistering. So, of course, they decided, the lessor, the owner and the lessee decided to fight it off in a court in Sri Lanka, where they came to Sri Lanka and tried to repossess the aircraft. Now, I understand the Chicago Convention is a public international air law instrument, which, as I read out before, we had in its preamble to promote amity, avoid conflict among nations. Whereas the Cape Town Convention, which deals with regards to which makes provisions for rights of owners, lessors, and other interests in aircraft, has not yet been signed in Sri Lanka, and it's not in force in Sri Lanka, but it comes under the regime of private international air law, where rights of individuals and parties, individuals and bodies, are to be determined in accordance with the principles. Now, I would have a serious issue with regard to which should be accorded primacy. Is it public international law or some convention, although this convention is not in Sri Lanka, to protect the rights of individual parties? I understand aviation has to have facilities, has to have owners of aircraft, has to have leases. These aircraft must be properly operated. But when these conventional principles are used for ideological, political reasons, that actually complicates matters, and then you cannot impute blame on one party. So then Russia, I believe, had invoked in the Council Article 89 to say that when there's a war, they are not required to adhere to the principles of the convention. So they said we don't have to comply with Article 15, having it only in one register. We will register it in our aircraft register. So now what happened was their conflict was played out in Sri Lanka. And unwittingly, it involved the state of Sri Lanka, where they used the court machinery to obtain an order. The owner of the aircraft obtained an order saying you should arrest the aircraft, not allow the aircraft to fly. Of course, this aircraft had so many passengers on board, and they were about to take off when the order was issued. But again, the manner of issuing the order was entirely procedurally wrong. And what actually happened is when an aircraft comes into Sri Lanka and it's at the airport, it's under the control and supervisory, it's under the regulatory control of the aeronautical authorities of Sri Lanka. An independent individual owner cannot go to the airport and seize the aircraft. There will be so many security implications. So all these were observed in the breach. If you look at the principles of the Chicago Convention, it has to be safe. You can't have, just because you are an owner, walking into an aircraft without proper authority. So all these were in breach. Then also the passenger rights. Passengers were about to fly off, they had to go to hotels. So these were the several legal issues that were brought in. And of course, the main underlying matter is whether the court had jurisdiction to hear the case, because the parties were not in Sri Lanka, the contract was not entered into in Sri Lanka, and the aircraft lease had been terminated when the aircraft was not in Sri Lanka. So there were so many things which did not allow the court to exercise jurisdiction. So this is my commentary on, of course, I must say it may be deemed biased because I was representing one of the parties, but on an overall perspective, both public and private international law, my view is we should give primacy to the Chicago Convention and its principles, and that should have deference to the implementation of any rights derived under private international law treaties. This, I would love to hear your comments on this.
Thank you, Lasantha. I was about to ask for the flow just to support what you said in terms of the primacy of legislation. Now, we as lawyers, I find even lawyers here in Canada and elsewhere, and even law students, we talk a lot of the rule of law. It's a basic common law principle. And we all know what the basic principle of the rule of law, equality, publication, and so on. But a fundamental principle of the rule of law is compliance with a state's obligation in international law, meaning the treaties. Now, when Lasantha talks of the Chicago Convention, the Vienna Convention on the law of treaties very clearly has a provision which says if there is a clash between domestic and international law, treaty law, the treaty law must prevail. Now, this is a basic tenet of the Vienna Convention on the law of treaties, which is customary law. You don't have to ratify it. So the basic principle, that's the point where we deviate and we perhaps neglect. Sometimes we tend to sort of put primacy on domestic law or international law after ratifying a convention. It is only when a state ratifies the convention that the convention takes it to effect for that state. So the basic principle is the primacy, and if a convention says something and a state ratifies that convention, that state has to, under the principles of the rule of law, has to abide by it. I might just mention an interesting fact about Sri Lanka. Montreal Convention was ratified by Sri Lanka, and the Montreal Convention in Article 57 says this convention cannot be subject to any reservation by any state, meaning all provisions apply, except in the event that the state invokes its principle of sovereignty, or it applies to military transport, which is Article 3 of the convention. A state can record its reservation, and Sri Lanka has recorded that reservation, which means Sri Lanka has retained its right to go beyond the convention for a purpose of interest of sovereignty or military or state aircraft transport. So basically what my thinking is that the primacy of international treaty law is an established fact under common law, at least. Now, I have another comment on Article 89, which was very relevant, mention of from Lasanta. Article 89 says, in case of war or in case of emergency, the provisions of this convention shall not apply to any belligerent party. So even in a state of emergency, it won't apply, but there is a condition: you must inform ICAO. Now, in these instances, I don't know whether ICAO was informed or not, because if ICAO is not informed that there is a problem in a country, now this happened in MH17, where the aircraft was blasted over Ukraine. ICAO was not informed, as far as I know. So the provision did not apply, kind of. So one has to be very careful in terms of adhering to international law. The cutoff point is, of course, ratifying. You can, if you ratify it, you're bound by it.
Okay, thank you, sir. And there are two more questions I think you can quickly answer. There's one question, it doesn't say to whom it is directed at, from an anonymous attendee. What are your thoughts on imposing fines in SDR rather than in LKR, according to Civil Aviation Act number 14 of 2010? I think Dr. Hettiarachchi can say something.
Yes. SDR, this liability was initially formulated in the Warsaw Convention, which was given in French francs. And then, of course, French francs were determined. The quality of the French franc had to be of a certain quality of gold, French gold francs. And there was a very big problem because it was in French francs, and each time an accident occurred in US or different countries, the damages had to be computed on the basis of the value of French francs on a given date. And this was one of the biggest problems that ailed the Warsaw Convention, and also frequently arose in litigation, which actually was avoided by bringing in SDR. SDR is special drawing rights. It is a basket of currencies taken from different currencies, an average of different currencies at any given time. And there is a value ascribed to it. So it's very easy to compute a value. At today's value, SDR is, according to what I just Googled a little while ago, was 430 rupees at one SDR. So here again, it is good to have this value, because I will refer to a particular case. I do not know whether people, most of the attendees will recall. It was, I think, in 1998. There's a Lion Air, Sri Lankan domestic carrier operating flights from Colombo to Jaffna during that time, was shot down by the LTT, and 58 persons perished. 54 passengers and 4 crew members perished in that incident, and several family members of the people who died brought action in court. And unfortunately, because it was domestic carriage at that time, the limit of liability that applied to passengers was deemed to be $5,000 US. And the dollar at that time was, at the time when the action, it was settled in Mount Ravinia District Court, about 10 actions were brought in collectively, it was settled. The dollar was going at about 90 some rupees at that time, the US dollar. So approximately each family of the deceased parties received less than 500,000 rupees. Now I cannot conceive how that would have been sufficient to compensate those families for the loss of their family member or breadwinner in those situations. So, and sometimes even in the event of death, now we have, why is uniformity necessary? You might have passengers taking a flight on an international journey where you have a Sri Lankan passenger and another person from a different country, where they have totally different economic situations. One person might be from a wealthy background, and if that person dies, his family should be able to be compensated. Now, in the same situation, even in this country, there are people who would have different financial circumstances, and they will have different quantums of damage that they have suffered. But what is important is, here we once again go back to the principle that you have the payment of damages is based on restitution, which means you have to actually prove the quantum of damages. So if some person proves my quantum of damages is 75 million or higher, or someone can only prove 10 million as a result of death of injury, that person would be entitled to that amount of damages. So whether it is in SDR, that is what is given in the convention for the purpose of uniformity, but the money will be paid if it's in Sri Lanka, in Sri Lankan rupees, at the corresponding value for an SDR on the date of payment. I hope that answers the question.
Okay, sir, thank you. And we have one last question. This is actually not relating to aviation law, but I think Dr. Abhiratna could answer this. How can a Sri Lankan lawyer land a job overseas regarding space law? How can it be done?
It's interesting. I mean, I don't know. Here in this part of the world, there is a lot of emphasis on publications, peer-reviewed publications, which means that you have been accepted by the international community. But above all, if a Sri Lankan-based lawyer wants a job in space law, I can vouch for this. I through my colleagues and all that. If you write to a professor of space law in the Institute of Air and Space Law in McGill, or a known space lawyer, they will give you a very good answer, even help you with their contacts, because people in this part of the world have a lot of contacts. They are looking for young people. They are looking for creativity, innovation, and all that. So you have to demonstrate that first. It's like, what do you have to offer? And start off with an interest in space law, and then take it on. I don't think it's difficult.
If I may, this sir. A couple of days ago, I had the privilege of addressing the United Nations General Assembly 78 on Space Summit. That was on Thursday. And one of the keynote speakers spoke about the amount of work that is done in India, the tremendous amount of work that is done in the space applications industry. In Sri Lanka also have so much of opportunities. Unfortunately, due to the lack of awareness and information, people, particularly lawyers in this field, are not aware of those opportunities. I mean, you can start by publications, but I would say so much of information is available in the public domain. Get yourself interested in the topic. Discussions are going on. Enough and more opportunities abound. Talk to people, start writing, start researching, and equip yourself with a little knowledge. I know the Kotalawala Defense University is looking to start a program on space law, and I think it's time that several other institutes also look at teaching some space law. And there is material and there are opportunities out there. You have to pursue that, persevere and find. And tremendous opportunities in the East exist, not only in India, in Singapore and entire East, there are lots of jobs in the space law industry.
Good point, Lasantha. Just to add, I see a lot on the World Wide Web of the University of Colombo, the Defense Academy and all that, forming alliances with the University of Warwick, Monash University, all kinds of places. That may be one way to go to establish a system of education, a broad-based system of education. I know one or two institutions might do it, that might sort of be an impetus, and it will sort of suffuse Sri Lankan lawyers with the interest that this very fascinating area generates.
Thank you very much. Thank you very much, Dr. Wanti Saberatne and Dr. Lasantha Hettiarachchi, for sharing your knowledge and expertise with us. It was a very fruitful panel discussion, and answers to the questions were very interesting and very educating as well. So now I hand over the floor to Dr. Asanga Gunawansa, the chairman of the Overseas Relations Committee of the BASL, for concluding remarks. Over to you, Dr. Gunawansa.
Thank you very much, Anusha, and thank you for conducting the webinar and managing the time, in a very excellent manner, and putting all the questions, both yours as well as the audience, to the two panel members we have. And I would like to thank Dr. Wanti Saberatne and Dr. Lasantha Hettiarachchi for finding time on a Saturday to spend more than 2 hours with us and educate our attendees. I'm told that approximately 150 attendees participated in this webinar, some on this platform and also some on YouTube, and also from different jurisdictions. And I also see among the list of attendees 3 other local experts, which gave me a bright idea of, continuing this discussion on air law, perhaps on another day, and inviting Mr. Ratnaveera Narvin, my good friend and old colleague, and also Mr. Senrath Liyanage. And also, I think there's another person that Janaka mentioned who was Mr. Vaniappa. So maybe we can get all 3 of them to participate in another session, and we can have more interesting questions. I myself had a couple of questions to ask, starting from what happened in Malta in 2012, and then to what happened in Sri Lanka with Aeroflot Pace, but maybe that I can save for another forum. So thank you, gentlemen, for giving us your time. And I'm sure the attendees certainly were well educated and well informed and benefited a lot from this session. And I would also like to thank our President Kaushal and Amaratna and our Secretary Isru Bala Patabandi for the support that they have given us. And as the Overseas Relations Committee, I would like to also thank my co-chair Champika Amarasekara, and also my convener Janaka Basuri and the other committee members, and also Nelum and Ridma for all their support in organizing and conducting this webinar. So thank you very much. Until we see you again, enjoy the rest of the Saturday and have a good night, everyone. Thank you.
Thank you very much.
Thank you very much, and good night.
Thank you.
It was very enjoyable time to be spent with the colleagues of the profession.